you with the facilitator. Can I quickly go and collect that and I will get back? But it was sent simultaneously to all the parties. I also have a register in the registrar's office that I'm following on.
Justice Naps, it occurs to me that the gentleman may be referring to the direction for the filing of heads on the question whether the matter should proceed as a virtual hearing. I think those directions might have been sent out around about 5 May.
Mr. Montepane, it appears to me that you referred to my brother Roger's that the 5th of May was the directive from court in relation to further conduct of this matter. But everybody else received months ago the notice of set down of this matter as per this date, the 26th of May. Are you with me, Mr. Montepane?
Yes, I'm with you.
Right. So when everybody got the notice of set down, people filed it as at that time, including the respondent, including the appellant, including the amicus curiae in the matter at the moment, the counsel for the advancement of the South African Constitution. So you would have received it. The directive was a separate issue. It involved a communication between us, between the court, between the registrar and Mr. De Beer, and all the other parties, including you. The point is, though, you knew months ago, you must have known months ago because of the notice of set down of the 26th, that heads had to be filed, if you wished to file heads.
My Lord, we have not received any correspondence of such, except the correspondence that we received recently, that of the heads. That is the only correspondence we've received.
But you only filed heads yesterday, am I correct?
You're correct.
This morning.
Yes. Mrs. van der Merwe, do you have those dates, please, and the receipt by the Ola Bond Renaissance?
Judge, I'm waiting. I've asked the book for that, and as soon as I have it, I will give an indication. They just collected it from the office, and with regard to the heads, the date indicated on the heads is 4, but it was received this morning. It was today that it was received, not yesterday.
All right. I still want to know whether we have proof of service on the Ola Bond Renaissance.
Yes. I'm attending to that, Judge, and I will give an indication.
All right. Well, let's go back to the beginning. Mr. De Beer, you filed an application for a recusal.
That's correct, Judge. No.
Well, do you wish to address that now so we can deal with it, and do you wish to argue it right now?
Judge Nafsa, the application was lodged on Monday.
Yes.
We have not received any information or notice from the court that the matter would be set down for argument also today.
No.
In the notice of motion, we have also indicated that any other parties that's referred to obviously as the appellant and the amicus curiae CUSAC have 30 days in terms of the rules to also file their opposition if they want to.
Mr. De Beer, I will ascertain now from either of the other parties whether they wish to file affidavits. Today is the matter. The matter has been set down for today. There's been a directive. There's been an exchange. Your initial attitude was that you're absolute about not attending, that you wish to have a hearing in person, and we'll deal with that as a separate issue. The point, though, is that you've applied for our recusal. We should hear that because we shouldn't be sitting at all in any of the matters, in preliminary or otherwise, if you're correct. If you're wrong, then we'll continue hearing it. Or if we decide not to recuse ourselves, then we'll continue hearing. So either you will persuade us that we are we should recuse ourselves or not. But let me ask the other counsel whether they have anything to say. So, Mr. Trengrove?
Yes, we certainly oppose the application, but we do not wish to file any paper.
Mr. Butlinder?
Judge, our position is the same.
All right. Mr. Motopeng, whilst we're waiting, your position?
We support the respondent.
In the application for the recusal?
Yes.
Yes. Well, Mr. De Beer, we're all here. You're able to move it. So you can put your argument to us as to why we should not be sitting in this matter.
Judge Nafsa, the Article 13 of the Judicial Code of Conduct specifically said that, above others, that the judgment for recusal must be made in open court. So it is less likely that it appears from the wording of the Judicial Code of Conduct that the argument for recusal must also take place in open court. Or that is the position. We have been very strict on the reasons. We've also stated why we respectfully move towards a recusal application, and it's all to do with the holding of the virtual hearing, and we've also given the reasons for it in the application itself. So the question that Judge Nafsa must answer and the other judges is whether the Article 13 of the Judicial Code of Conduct allows for the matter to be argued not in open court, and for that matter,
so do I understand?
We of the position that
do I understand you correctly that you wish to have that question addressed first, whether or not we should have this hearing and whether or not we're entitled to adjudicate through this virtual hearing? And if you wish to address us on that, then you must address us. If you do not wish to participate virtually in addressing that argument, it's up to you. But there it is. If you wish to address us on whether or not we should hear you, you must decide what it is you wish to do. I see that my brother Rogers seems to want to put something. No? No. Anyway, Mr. De Beer, so it's up to you. You decide whether you wish to move the application for recusal before us virtually, or you decide you wish to address us on whether we should have a virtual hearing, in which event we will hear you, we will hear everybody else, and we will then make a decision. But if you've, on principle, if on principle you wish not to address us, that too is your choice.
Judge Nafsa, as I believe we have got the right at the end of the day also to properly argue with proper heads of argument the recusal application. Because of the fact that it has been lodged 2 days ago and accepted by the Chief Registrar as being temporarily filed, and we've also lodged the formal original documentation yesterday morning at court itself, that is a new application before the court, and we are of the view that a proper enrollment for the argument there to need to be done, and we are not in a position at this stage to properly argue the matter and also obviously we haven't had the opportunity
Mr. De Beer,
to file heads of argument.
Let me understand your position. I'd like to understand it properly, and perhaps each of my colleagues could put you such questions as they have. Let me understand the position. Are you contending now that you do not wish to address us at all virtually? Because that's the one position. Are you contending you're willing to address us virtually, but you wish for more time to address us on the question of our recusal? What is it exactly that you are contending? I'd like to understand that. So take a minute, think about it, and tell us what it is.
Judge, Judge Navsa, thank you for the opportunity to explain myself. If we would move for a virtual hearing, it will really defy the odds or the reason for the recusal, as well as also the reason why we did not want a virtual hearing. And we were thoroughly aware of the fact, and we have stated it per letter to the court specifically, that our case is unique. It's not like any other virtual hearings. If we put ourselves in the position, that was the argument from the region, from the word go, why we disputed the directive that was issued for virtual hearing. We said that our case is unique. The very
Mr. De Beer,
measures
Mr.
that
De Beer,
were introduced, yes.
Mr. De Beer,
we cannot proceed
Mr. De Beer, I'm sorry.
with a virtual hearing at all. Otherwise, we will, yes.
Mr. De Beer, just let me understand this. And it's important that we clarify it so that there's no misunderstanding. Is it your position that you do not wish to address us at all virtually? Is that your position? On any matter, whether it's on the recusal, whether it's on the appeal, whether it's on the question of whether or not we should have a virtual hearing. I just need to understand whether that is your position.
Judge Navsa, we cannot address this the court if on a virtual platform. According to us, the recusal application must be addressed before any other thing.
Mr. De Beer, just listen very carefully to the question. And then it's either yes or no. Just listen very carefully to the question. Do you wish to address us at all virtually on any aspect, whether it be the recusal, whether it's on whether or not we should have a virtual hearing, or whether it is on the merits? I just need to understand that.
Judge Navsa, I don't know whether I'm being heard properly, but we cannot.
We hear you.
Proceed virtually. Well, we cannot. Yes. So we cannot participate in something that we believe cannot proceed. Then, in that sense, respectfully said, anything personal against any one of the judges sitting. We don't know any one of the judges, but the circumstances have forced us in the position that we cannot simply accept the virtual hearing to proceed. Well, we are of the view simply that there is no other alternative but to postpone the matter in order to address the recusal application, and from there on, after the judgment was rendered in open court as per Article 13 of the Judicial Code of Conduct, we are then in a position to proceed as the court then directs. That's our position.
Can I just get clarity so that we just, it's almost like a dog chasing its own tail, but there you have it. Can I just establish from you, are you suggesting to us that you elect not to participate on this virtual platform and you elect not to participate in these proceedings?
Judge Ponan, it's not a matter, respectfully said, of choosing to continue or not on this platform. The unique circumstances of our matter puts us, unfortunately, in the position because of the fact that the very measures which have pushed the court into a virtual hearing are, according to us, the very measures that we are going to argue in the main appeal. So if we proceed, we're going to shoot ourselves in the foot. And then we are tacitly going to agree that this forum is properly founded and that we can then proceed. But we cannot put ourselves in a position to even tacitly anticipate a virtual hearing at all, with all due respect to...
Do you appreciate that on the approach that you adopt, you run the risk of this court proceeding with the matter in your absence because you've chosen not to participate in these proceedings for whatever reason. I mean, I don't want to get into the reasons with you. But do you appreciate that you are free to decline to participate, to withdraw yourself from participating in these proceedings? But in that event, my colleagues and I would then have to consider whether or not we proceed in your absence. Do you appreciate that?
Justice Ponan, with all due respect, I don't believe that any one of the judges allocated to this matter is in a position to proceed with this matter before the recusal application has been dealt with. If it is the justices who are implicated in the recusal application's standpoint that you may proceed adjudicating or hearing the matter or deliberating the matter virtually, where the Article 13 of the Judicial Code of Conduct specifically says that the judgment in any event must be in open court. So that implies to me that even if the judges decide to virtually continue, you must go and deliver the judgment and the reasons for the judgment in open court in any event. So that is our
you are getting ahead of yourself.
It is a very
I'm sorry, Mr. De Beer, you're getting ahead of yourself. I mean, let's just see if we can't confine the debate somewhat.
Wow. I don't know
yes,
that much.
Papers were issued which suggested that the recusal of my colleagues and myself would be sought. But until and unless that application is properly moved before this court, we're not seized with it. It's not before us. So to talk about a recusal application at this stage is somewhat to put the cart before the horse. Now, if you want to move the recusal application, that would be an anterior question that we've got to decide. You're free to move it. But until there is a formal application before us, it seems to me that we need not detain ourselves with whether or not we should be recusing ourselves. I mean, that's just not before us.
Mr. De Beer, you've heard the question. It's been put to you repeatedly. Could I just ask you this? You've said, because of the unique situation of your case, can I refer you to page 10 of your heads, if you have it before you?
Judge Davsa, I'll get it now. Heads of argument. Judge Nafsa, is it page 10?
It's page 10. Yeah. It's paragraph 2.15.
.15, is that correct?
2.15, yes. Just read it aloud so we can.
Yes, I'm reading.
You can read it aloud so we can all hear it, and then we can talk about it.
Well, we have said
sorry, Mr. De Beer, it would help if you just listen to what I'm putting to you. Would you just read it aloud so we can get it on record, so we all know that that's what we're dealing with, and then we can take it further. So start off by reading it aloud, and then we can take it from there.
Yeah. Paragraph 2.15, page 10 of the respondent's heads of argument reads as follows. It appears as if all the courts in our country, notably via Davis J, in our own matter, have already accepted, without making any ruling on it, that COVID-19 actually does exist, and it is a pandemic, thereby justifying measures to to be taken in combating and preventing the alleged spread of it. Except in our case, it further appears as if no applicant in any of the cited cases has actually challenged the existence of the claimed COVID-19 disease. That should have been respectfully the point of departure for any court. Without COVID-19, there could not have been DMA regulations. Full stop.
All right. Could I ask you that? Is that what you say is unique to your case? Mr. De Beer?
Judge Navsa, we are, the court or the judges are putting me in the position to start to argue the matter, which I, at this stage, don't want to
then let's go to the beginning
with full respect. But the fact is that the measures, yeah.
Well, all right. So let's go back
to
the
measures we are talking about specifically.
Mr. De Beer, let's go back to the question that Judge Ponnen posed to you and that I've been trying repeatedly to get you to respond to. And I don't want you to repeat what you've said already. Just respond to the question as concisely with a yes or no. It's as simple as that. Is it your position that you refuse as a matter of principle to address us virtually on any of the issues that you have raised and that are raised in the appeal? So let's start with the first one. You do not wish to address us virtually on whether or not we should hear you virtually or whether we should hear you in open court. Yes or no? It's a
Judge Nafsa?
It's a simple question, Mr. De Beer. Yes. Yes or a no?
Judge Nafsa, respectfully said, you have mentioned the name or the phrase. It's not a matter that we refuse to. We're saying that we can't, and if we can't, it means that yes, we're not proceeding on a virtual platform.
So let me just get now absolute clarity. You have adopted the position that you are not going to address us on a virtual platform in relation to whether or not you should be heard virtually or in person. You are not going to address us virtually on our recusal. You're not going to be moving the application for our recusal virtually, and you're not going to be addressing us on the merits of the appeal virtually. Yes or no? It's as simple as that.
Judge Nafsa, we're not going to participate in a virtual hearing at all. We have identified, especially in the recusal application,
Mr. De Beer,
why we're not going that route.
Mr. De Beer, I've put to you those questions. Am I correct in accepting that your answer to them are yes, you won't? Mr. De Beer, it's not a complex question, it's a simple question.
Yes, we can't.
All right. Well, very well. Let's now understand what Mr. Moteng's position is. You've heard Mr. De Beer. Do you associate yourself with what he has said, Mr. Motupeng?
Yes, my lord. Our argument, the basis of this court matter or the application is the issue of COVID. Is COVID a disaster or not?
Sorry, Mr. Motupeng, can I just stop you? Are you saying that your argument is based on whether or not COVID exists? Is that what you're putting to us?
No, we are saying it's based on whether COVID-19 is a disaster or not. A disaster, meaning influenza is disaster or not. Meaning is cold a disaster or not? Because all those are pandemics.
Mr. Motupeng, listen to what I'm putting to you.
Yes.
To understand whether you associate yourself with Mr. De Beer, that as a matter of principle, you do not wish to participate virtually in this hearing on any of the aspects that are raised either by him or by any party in this matter. That's all I want to an answer to. Yes or no?
Mansa is that's the only thing we are requesting here, my lord, is to have access to that. And we are saying this platform has been allowed. It is
Mr. Motopeng, Mr. Motopeng, you've heard the questions. Do you wish to do you associate yourself with what Mr. De Beer has said, yes or no?
I see that this platform has already taken a biased position against what the application is brought to the court, and the court must be fair and just. So we are asking the court to be just.
Mr. Motopeng, the question is a simple one. It's not a complex question. Do you associate yourself with the position that Mr. De Beer has put to us? Yes or no? It's as simple as that. It's either yes or it's no.
My lord, the role of the court is to treat us fairly and equitably. And in so saying, when I say yes, I would say yes. I have to justify to say that I will request the court to be fair. To be fair to all of us in terms of...
Well, you've heard Mr. De Beer say if he were to address us on it, he would be shooting himself in the foot because he would be subverting his own case in that he didn't want a virtual hearing. Do you wish to address us on any aspect, or do you associate yourself with Mr. De Beer? It's not a difficult question, Mr. Motopeng. It's a straightforward question.
When we approach the court for an interview to what the state and the public as a concern, the conflict that is taking place. And the conflict that is taking place, it's the visual, it's one of the elements that the state is using to mitigate or to minimize the impact or to deny the rights of ordinary South Africans who might not even have data to be able to present themselves to the court.
Mr. Motopeng, I don't know how many more times I can ask you this question. I've asked it again and again and again. I'm going to try one last time.
We agree. We support and in addition to say that in terms of Chapter 34 of the Constitution, in terms of access to the court must be able to grant us access. That's all we are requesting. I support DPS, LFN, and we support DPS. But furthermore, we call for the court to abide by the Constitution and adhere to Section 34. To Chapter 34 of the Constitution, and furthermore to ensure that the Bill of Rights are adhered to, and not to limit our Bill of Rights.
I'm sorry, you're getting ahead of yourself.
Technology.
I'm sorry, you're getting ahead of yourself. Can I? And this ties in with the question that's been put to you by my brother presiding. You see, you are now arguing your case, and you are arguing your case on a virtual platform. Now, it seems to me, if you make common cause with Mr. De Beer, then you would no longer see your way clear to participating on the platform. If that is so, then you must indicate as much. But if, unlike him, just let me finish, please. If, unlike him, you see your way clear to participating on the platform, then of course you can address these arguments to us. But you can't have it both ways.
What we are merely doing is we are registering our concern to the court for the court to decide on our concerns. Remember, we are not only speaking for ourselves; we are speaking for millions of of poor people who don't even have access, who've been turned around at the court's gate to be able to go on to apply online, and they don't even have internet. They don't even have access to internet because of this new system or this new era or this new dawn, which we are saying. That's we are
you do appreciate though that if we were sitting in Bloemfontein, I mean the argument seems to suggest that you would have millions of people descending on Bloemfontein in order to access the court. But put that to one side. Let's just park that to one side. You still haven't dealt with what I've tried to raise with you, and that is whether or not your attitude, because you see you're now making submissions in relation to one of the aspects that we asked to be addressed. We asked whether or not any prejudice could be pointed to. And as I understand Mr. De Beer, his approach seems to be, well, he's not participating at all. You seem to be saying you make common cause with him. Logically, it seems to me it would follow from that you also don't see your way clear to participating. If that is so, well, then you should indicate as much. If it isn't, then you will stay and participate in the proceedings at whatever level you feel comfortable at participating.
Mr. Motopeng, you must make a decision now. Do you wish to address us on the merits on anything, on whether or not you should participate virtually and address argument on that aspect? Do you wish to address us on the recusal application? Or do you wish to move a recusal application? Because as far as I understand it, you haven't lodged a recusal application. Mr. De Beer has, and he hasn't decided to proceed with it virtually. He doesn't want to do with it virtually. So, do you wish to address us on the virtual platform and whether it should be adhered to and advance argument, in which event we will hear you? Do you wish to address us on the merits of the appeal, in which event we will hear you? Or are you in agreement with Mr. De Beer that you do not, as a matter of principle, wish to participate? Yes or no, Mr. Motopeng? We're not going to have a repeat.
Yes, it is a matter of principle that I cannot participate in a platform that limits the rights of many South Africans to participate in.
Thank you, Mr. Motopeng. Thank you,
Mr. De Beer. I'm sorry, my brother presiding. Could I ask Mr. De Beer something?
I think he's left.
Oh, has he? That's a pity.
I think he's left. I can't see him on the platform, but he seems to have gone now.
No matter.
Sorry. There he's back on the screen. Yes?
Judge, I have just muted and taken off my video.
All right, Mr.
For streaming purposes.
Justice Ontalte, you wish to put something to Mr. De Beer?
Yes. Mr. De Beer, you're not a lawyer, so might I just ask you whether you would give consideration to this? Would you consider participating on the virtual platform while reserving all your rights by using the platform for this purpose in respect of the arguments you wish to make about recusal and any arguments you may then want to make about the constitutionality of using a virtual platform? In other words, the fact that you're using it for the purpose of addressing these issues is not going to should not be understood at all to be a concession that you accept that this is a proper way in which courts should constitute themselves for deliberation. Is that something that you would consider?
Well, I don't know when that is. We're in Cape at the moment. We're moving back to Gauteng, and then from there we're going to KwaZulu-Natal again. So I will make that known on my, oh goodness, I'm busy live streaming the court case this morning.
Mr. De Beer.
So I will
Mr.
put
De
on
Beer,
my Facebook page.
I see he's leaving.
I will make it available on my
Very well.
Facebook page and on the YouTube channel. Where are you based in the
Mr. Motopeng, I think you've made your position clear, so
North Coast.
I'm going to turn to counsel now.
The best is we'll only come to the North Coast if people want us there and organize a meeting, because we don't actually organize meetings.
May it please the court.
Thank you so much. Okay, keep well, bye.
Yes, I have.
Well, in respect of a virtual hearing, I assume that you have nothing further, but you can tell me differently if you wish, that you have nothing further to add to what the exchanges have thus far been between yourself and the registrar and Mr. De Beer. Correct?
Yes, indeed, we have nothing to add.
Justice Max, I see Mr. De Beer is back with us.
Yes, Mr. De Beer?
Yes.
I don't know if he wishes to address Judge
Apologies.
Yes.
Judge Unteelter, I did not hear your question. We unfortunately went offline. Apologies for that.
Mr. De Beer, I was putting to you the following possibility, that you would consider using the virtual platform to address, if you wish, your recusal application and the constitutionality of using virtual platforms on the basis that use of this platform for this purpose is without prejudice to any of the arguments that you wish to address to us as to either the recusal or as to the constitutionality of using virtual platforms. Is that something that perhaps you would give consideration to in approaching this matter?
Judge Unteelter, the proposal that I understand is that we should then move to virtually attend to the recusal application, and then we can, then the judges can then decide the matter afterwards. But the problem that we are sitting with, and this is a question to all the judges, respectfully, that in terms of the guidelines set out in Article 13 specifically of the Judicial Code of Conduct, in terms of Note 13.1 of that, it does say that the judgment and the reasons must be in open court. Does that also, and also that the principles of a fair hearing must be applied. So does that allow, for example, the judges to hear the matter virtually, and then...
Mr. De Beer, I don't think you're following my question to you. I'm just saying this. If you use the virtual platform to address the question of the recusal and say to us, by using this platform, you should not understand that I concede at all that it is constitutionally proper.
Yes.
You can then make your arguments without your fear that by using the platform at all, you are prejudicing the arguments that you wish to address to us. I'm just putting that to you as something you may wish to consider because you're not a lawyer, and this may be a way we can move forward. Or you can take the option you appears to have taken, which is that you will have nothing to do with the virtual platform for any purpose, in which case we understand your position.
Judge Unterelger, the situation is that in the recusal application, we do address the issue about the virtual hearings too. We're not attacking constitutionally the holding of virtual hearings, but we do emphasize in that very application that our situation is unique because the person or the entity who have created the measures of COVID-19, which have given the foundation for virtual hearings in litigation, in civil litigation, to proceed since the 26th of March last year, is before this court, and those very measures are in dispute because we've already succeeded in a court order declaring those very measures unconstitutional and invalid.
Mr. De Beer, you don't need to start addressing the issue. It's simply, do you wish to use the platform without prejudice to the arguments you're going to address to us on recusal, or do you not wish to use the platform? So if you could perhaps just, I'm giving you an option which you may wish to consider, but if the answer remains you don't wish to use it, so be it.
Without any disrespect to the judges of the Supreme Court of Appeal, but yes, we need to align ourselves with the first answer that we gave, that we cannot proceed virtually addressing these things or these arguments, because then we will shoot ourselves in the foot.
Thank you. Justice Rogers, I thought you had your hand up.
Yes, Mr. De Beer. I just wanted, it really builds on what Judge Unterhalter asked you. The reasons why you say you can't proceed with a virtual hearing, and you start referring to Article 13 and then why you would be shooting yourself in the foot. Those are all the sorts of reasons which you could, without prejudice, argue to us virtually. You could explain to us why we should not proceed with a virtual hearing. You could use the virtual platform for that purpose. But do I understand your answer to Justice Unterhalter that you are not willing to use the virtual platform even for the limited purpose of putting up your arguments as to why we should not be proceeding virtually? Because in a sense, part of your answer starts moving towards your justification for there not being a virtual hearing, but on the other hand, you don't seem to be willing to address us fully on a virtual platform as to why we should not be proceeding virtually.
Well, that's why I am creating
Judge Rogers, if it is indeed without the prejudice that you have mentioned a few minutes ago, then we are much aligned to accept. It's merely in the interest of justice, in order to proceed with the judges understanding the recusal application, and then thereafter can then proceed as the judges decide afterwards. Yes.
Sorry. I think we might be getting lines crossed. Do you wish to move the recusal application virtually, or do you want to first argue that there shouldn't be a virtual hearing? Or do you not wish to do either?
Judge Nafsa, your question is somewhat different than the one that was put by Judge Rogers. We cannot, and yes again, we cannot proceed virtually. But on the grounds of Judge Rogers saying that on a no prejudice basis, we can explain to the judges why the recusal, or why these the recusal was moved. We are definitely open to address on a non-prejudice basis those very questions.
Perhaps I should get my brother Rogers to clarify with you exactly where it is we're headed. Because if you're going to be doing it virtually, then you're doing it virtually, and you're doing it on the basis that you reserve your rights while you're doing it. But what are you doing virtually? Are you arguing non-virtual hearing, or are you arguing just the recusal?
Judge Nafsa, we are not in a position to argue the virtual hearing at all. We're not bound by the virtual hearing concept now. What we're trying to address, as I understand, is the recusal application. And in that line, in order to move forward with the recusal application, on a no prejudice basis, we can proceed and present argument or explanation in that regard to the judges, and then the judges can make a consequently decision.
For my own purposes, though, Mr. De Beer, aren't the two inextricably linked? In other words, the fact, it seems to me, that we are proceeding with a virtual hearing, or want to proceed with a virtual hearing, as I understand the recusal application, gives rise to a reasonable apprehension of bias, suggests that we've sort of prejudged one aspect of your case, and therefore that justifies the recusal application. Now, aren't these two inextricably linked to each other?
Judge Poonan, indeed they are. But as the question was from Judge Rogers, would this, in order for the interest of justice and us not accepting that the virtual hearing, or that the judges were not biased in any way, presumably biased, in the interest of justice and for on a non prejudice basis, how Judge Rogers can maybe explain to us what he means by the non-prejudice basis, then on those grounds I can maybe give a final answer. Judge Rogers, if I may ask you that question respectfully.
Or through Justice Navsa, my point was really the same proposal as Judge Unterholter put to you. It seems to me that your fundamental objection is proceeding virtually, and that is, as Justice Ponnen has said to you, tied up also with why you are seeking our recusal. I was suggesting to you that without your conceding that there should be a virtual hearing, you could address us, make all the submissions you wish to make legally as to why we should not be proceeding on a virtual basis, and we could make a ruling on that. Whether it's heard simultaneously with your recusal application or whether we deal first with the question whether there should in principle be a virtual hearing or not. The idea would be you put up your arguments as to why you say we shouldn't, and we can then make a ruling on it. And by putting up those arguments, you would not, as it were, be conceding that the use of a virtual platform is correct. But the fact of the matter is we have to do one thing or the other. We have to hear an argument, and each side may say, well, doing it the one way shows a predisposition to one side or the other. We are here virtually, and my question is, are you willing, without conceding the validity of a virtual platform, willing to put up your arguments as to why we should not be proceeding virtually?
Judge Rogers, we can accept that without us accepting the validity of the virtual hearings. In order to address the recusal application, we can proceed with addressing same. As I understand that the recusal application has been provided to all the judges, and most probably all the judges have been afforded the time to go through the recusal application. Yes, we can proceed on that basis without acknowledging the virtual platform being used. Yes, the validity of it. Yes.
And what do you propose to do after that in one of two instances? So if we accept that you're correct and we should recuse ourselves, that's the end of the matter. If we incline in the opposite direction, what do you do then?
Judge Navsa, it is, as I've explained, that we'll be questioning the ability of the judges to make a judgment directly afterwards, for the reason, as I've stated way back in the beginning, that the judgment with the reasons, according to the Judicial Code of Conduct, must be made in an open court. So we cannot, after the arguments or after the recusal matter have then been addressed, the judges will then, according to our interpretation of the law, in any case have to postpone the matter for the judgment in open court.
Well, so let me understand this. You're willing to make the argument without conceding. Well, you're willing to argue virtually without accepting that you can argue virtually, that you ought to be arguing virtually. You will then argue and move an application for a recusal. You expect that decision not to be one delivered virtually, but one to be delivered in open court for its validity. Is that what you say?
Judge Navsa, it is indeed an enigma, yes, it is. Because it is a circular argument, and unfortunately, all of you have now been seized addressing the very regulations which have given rise to the virtual hearing concept. In that respect, it's unique.
I really don't want to go back to the question of it being unique. Mr. De Beer, it seemed to me you adopted a position which was absolute to begin with. So when you wrote to us you indicated you would arrive in Bloemfontein and you would demand to be heard physically. That was the position you adopted. You then filed an application for our recusal. What was put to you earlier today by Justice Unterhalter and Justice Rogers was that you consider participating in these proceedings as in toto. What you would then do is it would not preclude you from later on, assuming you were to go to a higher court, which I assume that's almost on the cards, that you will go to a higher court and you will be able to argue to the higher court that you reserved your rights, and therefore, although you participated virtually, you still want to argue that the entire proceedings, including the rulings and the orders that might emanate from it, are null and void and unconstitutional. So you're either all in or you're either all out with the prejudice, with the without prejudice scenario. So it's for you to make that decision. And if my brothers, Alter and Rogers, want to put to you anything in between, then it's up to them. But I think you've got to make a decision. We can't have you halfway in, halfway out, not putting conditions to us in a sense of how it will proceed. So I understood your position to be absolutist. What was put to you, as I understood it by my two brethren, and they can clarify it if I'm wrong, but what I understood them to say is, Mr. De Beer, we're inviting you to make the arguments in relation to all the matters. Virtual hearing, application for a recusal, depending on that outcome on the merits. And once you've done that and you either get a decision in your favor might be dispositive. If it isn't in your favor, you're not precluded from going to a higher court and saying to the higher court, they told me I could do this without prejudice and I participated. So I don't only want to deal with, and I'm just doing this as a for instance, as one of the possible permutations. I still want to argue that whatever they say, they might have said in relation to the merits is of no moment because the whole proceeding was a nullity. So that was what was put to you. And perhaps the two of them should clarify it with you, because if that's the position, then I think we must move on.
Yes. Judge Nafsa, you've explained it very nicely. Thank you very much. Our position is that we cannot and we will not participate in virtual hearings. Okay. To go further, what I would like to ask the Judge Nafsa, the implications, if we don't proceed with the virtual hearing, what would then be the implications of that from how are the judges going to proceed henceforward? Will the judges then proceed with hearing the matter as normally enrolled, or what will the decision, will there be a postponement, sine die, or I just want to clarify that one question.
Well, Mr. De Beer, there was a directive. You challenged the directive. You challenged the validity of the directive. We are where we are, and we were willing to hear you on whether or not we should proceed virtually, whether it was constitutional. We're willing to hear you on your recusal application. If you decide not to participate, well, that's the end of the matter as far as you're concerned. We will then deal with the remaining parties and the issues as they remain without your participation. That's all I can tell you for the moment. Perhaps if Justice Unterhalter or Justice Rogers indicates whether or not there's anything they disagree with in respect of what I've put, they must say so. But there it is. Justice Rogers?
No, I'm satisfied that you put the end result fairly to Mr. De Beer.
And you, Justice Unterhalter?
I too.
Justice Mbata, Justice Ponnen?
Yes, I'm satisfied.
Justice Ponnen?
So am I.
All right. Well, there it is, Mr. De Beer. I assume that you would now want to be excused.
Yes. Judge Nafsa, thank you very much for clarifying that. It is our stance for the record that all further proceedings henceforward will not be valid, and we then request excuse from these proceedings.
Thank you very much. You're excused.
Not to participate fully, but to just be on to still be locked on to see the proceedings further for our record purposes.
You're excused, Mr. De Beer. Mr. Motopeng,
thank you.
Mr. Motopeng, I assume you wish to be excused as well.
Before my lord, I wanted to.
Sorry,
the court.
Mr. Motopeng, it's not my lord. The form of address here is justice. So any of the justices are addressed as justice. Justice Nafsa or justice?
Oh, justice.
Yes.
I apologize, Mr. Justice. I wanted to refer to the Constitution in terms of 168 and 3.
Sorry, let's just look at.
No.
Just give me a moment. You wish to refer to which section of the Constitution?
Section 168.
Yeah.
Yes.
Mr. Motopeng?
And
Mr. Motopeng.
Wait, the may decide appeals in any matter arising from the High Court of South Africa or a court of status of similar to the High Court of now. I'm raising this. I'm raising this to say that the Constitution is the highest order in the House, and it oversees or over it is the, what is it? I wanted the right word, that the directives cannot oversee or supersede the Constitution. So I'm referring to this.
Mr. Motopeng, do you wish to make an argument at all? You've heard what was put to Mr. De Beer. Do you wish to participate in these proceedings virtually or not?
Not.
Well, thank you. You're excused, Mr. Motopeng.
Thank you.
Mr. Trengrove. You've heard. So let me start where I started. I'm sorry that we had interruption and we were going backwards and forwards. But could we start where we started before? As to virtual hearings, there was an exchange between the registrar's office and all of the parties. Everyone had their views expressed in an exchange. I assume that you abide and stick to yours. If you wish to add anything, please tell me. But I assume that what you put in that exchange via your attorney is the position you continue to maintain.
Yes, we submit that a virtual hearing is lawful, fair, and appropriate.
Yes. Mr. Budlinder?
Justice Nafsa, we associate ourselves with the submissions made on behalf of the appellant.
Mr. Trengrove, one other matter. We now do not have before us to be moved an application for recusal. We assume that the application for recusal in long form was served on your attorney and that you've had regard to it?
Yes, we have.
Is there anything you wish to say in relation to it? If there is, please let us know. And then I'll move on to Mr. Budlinder, and then we will then consider what to do thereafter.
Yes, let me address it very briefly. I would submit in the first place that the application has not been moved and is therefore not before you, and it is therefore not appropriate for you to consider it at all. If you decide that I'm wrong and that the matter is before you, then we submit that it is wholly unfounded for the following reason. The application stands on two legs. The first is that you ordered a virtual hearing, that you did so pursuant to the directions of the minister, that those directions were issued under the disaster regulations, and therefore that your direction presupposes the validity of those regulations. That's the first leg. The second leg is that by doing so, you have taken a decision, taken a position on an issue before you in the appeal. We submit with respect that it is wrong on both legs. As for the first, the registrar's letter of the 8th of April 2021, that's REC 6 to Mr. De Beer's application, made it clear that you directed a virtual hearing for reasons of health and safety. It's got nothing to do with the minister's directions. And therefore, your directive did not reflect any position on the validity of the regulations or not. But secondly, the validity of the regulations, in other words, the current status of the regulations, is not an issue before you in the appeal at all. The appeal before you is confined to the question whether the High Court correctly ordered the declaration, the regulations to be invalid. That's the only issue. Their status since that order was made, in other words, their status pending this appeal, is not an issue before you. I know Mr. De Beer argues it, but that's an irrelevant issue because that's not before you. So we submit with respect that the application for recusal is bad because it is incorrect on both its legs.
Just for the record, point out, just for the sake of my colleagues, that the position of the court, we did indicate in the directive that any party that considered the virtual hearing itself to be prejudiced by it could set out what that prejudice was.
Yeah. No, and no such prejudice was ever advanced. And we submit with respect, we don't propose to address you on it unless you would like us to do so. But a virtual hearing is lawful and fair and appropriate, and therefore there's no reason not to pursue it.
Thank you. Mr. Budlinder?
I have nothing to add, Justice Nelson.
Yes, very well. Well, we haven't had a formal application for recusal moved before us. I have had regard to the long form served on the parties. I cannot mero motu see any basis for us, for myself, or any of my fellow judges, my colleagues, to recuse themselves. And let me ask them if any one of them has a position on that. I can't mero motu see any basis for us not to hear the matter. Justice Connie?
I can't, like you, conceive of any reason why I should mero motu recuse myself in this matter.
Yes, Justice Mbata.
Thank you, Brother Presider. I also do not see any reason why I should recuse myself from hearing this matter.
Yes, Justice Rogers.
My position is the same.
Justice Intelton.
Mine is also the same.
Very well. Justice Mr. Trengrove, are you in a position to advance argument on the merits of the appeal?
Indeed.
Yes.
If you would permit me to do so, my little friend Ms. Hassan will address one issue, and that is the application for condemnation for the late filing of our supplementary notice of appeal.
Yes.
So with your leave, I will address the merits of the appeal. She will address that one issue, I may say, wearing a silk robe for the first time today. So if I may turn then to the merits of the appeal, Mr. De Beer has raised a range of points in limine, and let me address them one by one before I get to the merits of the appeal itself. His first point in limine
so sequentially, is Ms. Hassan going to follow you, or should she go?
She will follow me. Let me say that his first point in limine is that the supplementary notice of appeal was late. That is the issue that Ms. Hassan will address. The second point in limine is that the regulations are invalid because the High Court judgment declaring them invalid has not been suspended pending this appeal. And that argument is based on a judgment of the Constitutional Court in a case of new clicks. But let me deal with it very briefly because it is wrong and unfounded for two reasons. Firstly, it is a judgment of the Constitutional Court in the days before Oudekraal and Curlin, and has been overtaken by the jurisprudence of Oudekraal and Curlin since then. But secondly, even if I'm wrong, what the argument, high watermark of the argument, is that the regulations must be deemed to have been invalid pursuant to the High Court order because the appeal did not have the effect of reviving them. Well, but if that is so, it doesn't matter. The question in this appeal is still whether that order was correctly made or not. The status of the regulations pending the determination of the appeal is an irrelevance before you. So let me start with the first point. The first point is the principle of new clicks. It's a Constitutional Court judgment which has not been widely reported, but it's on the website. It's a judgment handed down on 30 September 2005. And it is a relic of the law before Oudekraal and Curlin. Because what happened was this. The Supreme Court of Appeal had declared certain single exit price pharmaceutical regulations invalid. The minister applied for leave to appeal to the Constitutional Court. Pending that appeal, there was a public dispute about the validity of the regulations struck down by the SCA order. The question was whether the application for leave to appeal suspended the order and therefore that the regulations remained in force or not. The minister then applied to the Constitutional Court for a declaratory order declaring that the regulations remained in force because the application for leave to appeal suspended the SCA order. The Constitutional Court dismissed that application for the following reason. It said that under the doctrine of objective invalidity, this is paragraph 15 of the judgment, under the doctrine of objective invalidity, a law which is inconsistent with the Constitution is invalid from the outset. It is not rendered invalid by an order declaring it to be invalid. It is invalid from the outset regardless of any court order. And for that reason, said the Constitutional Court, if there is an appeal against a court order declaring it to be invalid, then the appeal may suspend the court order, but it doesn't affect the underlying validity of the regulation, because the regulation under the doctrine of objective invalidity is objectively invalid, and its invalidity is not dependent on the court order. Or to put it differently, the appeal against the court order does not breathe life into a regulation which is objectively invalid. But you can hear that all of that reasoning predates the Oudekraal rule adopted by the Constitutional Court in Curlin, because that rule, if I may remind you, most recently been reaffirmed by the Constitutional Court in a case of Magnificent Mile Trading v. Sillier, 2020, Volume 4, SA 375, Constitutional Court, paragraph 51, where they quote from Odekerol and from Curlin as follows. This comes from Curlin. The fundamental notion that official conduct, i.e. regulations, that official conduct that is vulnerable to challenge may have legal consequences and may not be ignored until properly set aside, springs deeply from the rule of law. Now, I won't read on, you all know the rule very well, but the principle of it, in other words, is that although in theory we still have an underlying doctrine of objective invalidity, that doctrine only kicks in when there is a court order declaring a law to be invalid. And therefore, for as long as that court order is subject to suspension on appeal, the law is deemed to be valid until finally set aside by court order.
Well, if you got execution, you could, I mean, you know, there are the provisions, and they've never related to challenges to the validity of legislation, as it were, where you then have an automatic right of appeal, as it were. So that's not been employed in relation to legislative setting aside, has it?
No. Remember, when you're dealing with an act of parliament, the Constitution in any event says that the declaration of invalidity does not come into force until confirmed by the Constitutional Court.
That's right. So it has to go up the chain, as it were.
Now, in effect, the same rule now applies for subordinate legislation or administrative action, because under the Curlin rule, it is deemed to be valid until set aside. And until set aside means until set aside by a final order of court. And therefore now, when the order of court is suspended pending an appeal, then the default rule continues to apply, and that is that the regulation is deemed to be valid under the Curlin rule. So that now, Justice Nasser, you're quite correct. What happens is the ordinary rule that the fate of the regulation runs with the fate of the court order. The court may give interim effect to it, but the default rule is that an appeal suspends the operation of the order and therefore suspends the effect of the order of declaring the regulation to be invalid. So Mr. De Beer is wrong when he says that the interim status or the status of the regulations pending the appeal has been that they are a nullity. But secondly, even if he's right, it doesn't matter, because that issue is not before you. And I know he argues it before you as if it is an issue in the appeal, but it is not. You are required to determine whether the High Court was right or wrong in declaring those regulations to be invalid. The question of the status of those regulations since the High Court order and pending this appeal is not before you. So that it's both, Mr. De Beer is both wrong in law, but the point is in any event an irrelevancy to the merits of the appeal. The third point in limine is that the High Court order is not final. He says it's a supervisory order, therefore not a final order, and therefore not appealable. But there's really nothing to that at all. The court struck down the regulations, ordered the minister to report to the court, but is now functus officio. It's not as if the judge can now overturn those orders as if they were interlocutory orders. They were final orders, and they are unalterable.
They might have implications for what's happened in between, might they not, depending on the legality or otherwise of what may have been imposed using that.
Indeed. No, indeed. They may have all sorts of consequences, but the orders themselves are final orders and are not preliminary or interlocutory or provisional in any way. The fourth point in limine is one of preemption. The minister, at the end of December last year, on the 29th of December, the minister repealed and replaced all of the level 3 lockdown regulations. So, says Mr. De Beer, the Minister thereby gave effect to the High Court order and therefore, under the doctrine of preemption, has lost the right to appeal. But the doctrine of preemption is one which is founded on a principle of acceptance or of the validity and the finality of a court order. If one implements an order, you lose the right to appeal against it. But the evidence is that the Minister appealed and replaced those regulations in the ordinary course of repealing and replacing those regulations on a very regular basis. There is no suggestion in any record before you to suggest that the Minister did so in compliance with the court order. So
Mr. Tringove, you said the evidence suggests. I was going to raise that. It just seems to me there isn't evidence one way or the other.
No, there's no.
So there isn't evidence of acquiescence.
No, absolutely not. What there is evidence that the Minister has repealed and replaced the Level 3 regulations. That was, well, I'm not even sure that evidence is before you. What you might not know is that there have been applications for contempt of imprisonment and contempt of court and so on in the High Court. But you can accept that it is common cause between us that on the 29th of December, the Minister repealed and replaced the Level 3 regulations. But there is no evidence to suggest that she did so in compliance with the High Court order. There's one other point that Mr. De Beer has raised, not as a point in limine, but as a separate cause of action, which I will just briefly address. And that is that he says that under Section 59(4) of the Disaster Act, the Minister was supposed to submit her regulations to the National Council of Provinces. And because she failed to do so, the regulations are invalid. But you'll see that Section...
Does that deal with the Section 59 point?
Yes.
And the relative cross-reference to a provision of the Constitution?
Yes, indeed. Section 59(1) creates a general regulation-making power. But the regulations before you were made under Section 27, not Section 59. What Section 59(1) is a second empowerment provision, which creates a second regulation-making power conferred on the Minister. That must then be read with Section 59(4), which says that the regulations made under 59(1) must be referred to the National Council of Provinces for purposes of Section 146(6) of the Constitution. That is the section of the Constitution which says it deals with the competition between national and provincial legislation and determines which prevails over which, depending on the subject matter of the legislation. And what 146(6) says is that subordinate national legislation must be submitted to the NCOP to qualify for this competition with provincial legislation at all. If it hasn't been submitted to the NCOP, it doesn't qualify to participate in that competition at all. So there are two reasons why Mr. De Beer's point is, with respect, unfounded. The first is that requirement of 59(4) is a requirement expressly confined to regulations made under 59(1).
Mr. Tringove, doesn't Section 59(1), amongst those regulations, are any regulations which may or must be prescribed in terms of this Act? Section 27 is such a section.
No, but remember, that's merely a phrase from the section. What the section does say is that it confers a regulation-making power. And that is with respect an additional regulation-making power in addition to the one which already exists under Section 27.
And you say section 27 is specific and deals with particular matter.
Yeah, and it is a complete regulation-making power which exists under section 27. It is supplemented by 59.1, but 59.1 does not purport to confer the same power again.
What do you then make of 59.1a, though, that is a cross-reference to any provision? So it's a more generalized cross-reference.
Well, it is in the language of these provisions, of regulation-making powers, typically, where legislation says from time to time that certain things will be determined or prescribed by regulation, and they are then followed up with a regulation-making power at the end of the legislation, which says that the minister may make such regulations as are required to be made by this legislation. And so that simply refers to those cases where the Act provides for regulations but does not specify.
Well, can I just go back to 27? I mean, let's just clarify this because we need to get clarity in our own mind. So, the declaration of a national state of disaster is dealt with, and it tells you what it is that you can do, qua minister, in respect of a whole category or range of subject matter. That's where it stopped. And then it tells you regulations made in terms of this subsection or that subsection, and then we go to 59. The minister may make regulations not inconsistent with this act. So that's a sort of general power, and then it says, now, a must may be, and I haven't looked at every provision of the Act, there may well be peremptory provisions that compel a particular course of action, or the minister will deal with some subject or the other, and he will then make a regulation in terms of section 50. The next one is to prescribe for the effective carrying out of the objects of this Act. That seems to be much more general and beyond the more specific subject-bound range of section 27. The first one is it really is a cross-reference, and I'm not quite sure how you draw that distinction.
Can I just start with 27.2, because that's the empowering provision operative in this case. And that says that if a national state of disaster has been declared in terms of subsection 1, the minister may, subject to subsection 3, and after consulting the responsible cabinet member, make regulations or issue directions or authorize the issue of directions concerning etc. So it's a very specific regulation-making power with its own set of rules, including the requirement that it must be made by the minister, and it may only be made after consulting the responsible cabinet member. And then you will also see it subject to 3.
Sorry, can I just understand this? It does have the subsection 2, subject to the cabinet minister. And that's a very specific channel, isn't it? That channel is not replicated in 59.1.
No, not at all. And what's more, it's not only subject to consulting with the responsible cabinet member, but it's also subject to subsection 3. And if you look at subsection 3, then it lays down a set of criteria which must be complied with in making regulations under section 27.
You've got to measure it. That's got to be those are the jurisdictional facts, as it were, or the jurisdictional parameters. Mm-hmm. So there's a formal validating process by going through a particular channel, and then it's got to be tested.
Yes. And then, so the point I'm making, though, is that is a self-contained empowering provision with its own very specific requirements, both procedurally and substantively. And if you contrast that with 59.1, then 59.1 we submit is a residual and separate regulation-making power, less drastic, less stringently controlled, more generic than 27. So that it's not a duplication of 27, it is merely a second regulation making power in addition to the very specific one in section 27. But may I then submit that there is a second reason why the point is bad, and that is that the requirement in 59.4 says any regulation made in terms of subsection 1 must be referred to the National Council of Provinces for purposes of section 146.6 of the Constitution. It does not say that that referral is a requirement for their validity. It simply imposes that obligation on the minister to refer for purposes of 146.
So is the trigger that it must be within the parameters of 146.6 as it were? There must be a conflict, and only if there's a conflict does that kick in. That's really...
Well, let me say, in 146, in order to qualify for the competition at all, it has to be referred to the NCOP. So I'm not suggesting that the obligation imposed to refer it to the NCOP is a conditional obligation. I accept that the minister must, as a matter of course, when the regulations are made under 59.1, must refer them to the NCOP. But it's not a precondition for their validity. It is merely an additional obligation imposed on the minister once she has made regulations under 59.1 to refer them to the NCOP so that they may compete, they may qualify for competition with provincial legislation.
And Mr. Chenko, section 146 would only apply where there's a conflict between the national and provincial legislation only.
And if a regulation is not referred to the NCOP, the regulation isn't rendered invalid. It simply means that it then doesn't qualify for competition with provincial legislation.
Did the papers in this case identify any provincial legislation with which the regulations were said to be inconsistent?
No.
The case wasn't about which law should apply.
No.
Two conflicting laws should apply.
No, that's not.
So the opportunity provided doesn't even materialize, or doesn't eventuate, or doesn't. There's no base for it.
No, it's a desktop point thought of by Mr. De Beer. There's nothing. It has no consequence at all. Can I turn then to the merits of the appeal?
Just before you proceed, Mr. Trenproof, I think this would be for the benefit of the respondents. You've touched upon the doctrine of preemption. In the papers, Mr. De Beer or the respondents raised the issue that the appeal is moot and it would be of no practical effect. Yes, would you like to address us on that?
Yes, well, that submission proceeds from the premise that the minister repealed the level 3 regulations in compliance with the High Court order. And therefore, under the doctrine of preemption, the minister has lost the right of appeal because she chose to give effect to the High Court order. But there is just no factual foundation for that contention at all. We all know, you can look at the Government Gazette, she makes and repeals and amends regulations almost on a daily basis, certainly on a weekly basis. And as part of that process, at the end of December, on the 29th of December, made a number of changes, one of which was to repeal and replace the whole of Chapter 4, that's the Level 3 regulations. So it's true that those regulations have been repealed and replaced, but there is no evidence to suggest that it was done in compliance with the High Court order.
Mr. Trengove, I think the invocation of mootness is simply that the orders have no further practical effect because they've been overtaken, rather than preemption.
Well, the Conti has been Mr. De Beer's position thus far. Mr. De Beer's position is far more radical than that. He has said that when a regulation was struck down, then its successor in the new generation of regulations is equally invalid because the same ratio applies to its invalidity. So far from suggesting that they are moot, his case is that the court order lives on in the sense that it invalidates successive generations of the same regulation. But
if he's wrong in that, is the matter moot?
No, because the lawfulness of the conduct of
Mr. Tringrove, you seem to have broken up a bit. So perhaps you should just go back 2 minutes to what you submitted before.
Can you hear me now, Justice?
Yes, we can hear you now.
Thank you. You submit with respect that those regulations still determine the lawfulness or not of all who were subject to them during their period of operation. Their appeal has not been with retrospective effect, it's only with prospective effect. So they still regulate and determine the lawfulness of the conduct of everybody subject to them during the period of their operation.
Mr. Tringa, can I ask, I haven't looked at the December regulations. You say they replaced Chapter 4, which dealt with the Level 3 regulations. Did they also replace the Level 4 regulations or the March regulations, both of which were also declared invalid by the Court of Quo?
Justice Rogers, my recollection is that they did not, that they merely replaced the Level 3 regulations because those were the regulations in force at the time. But I can also tell you that lots of other changes have been made before and since then. So my answer is very tentative. I'm uncertain about it. Can I turn to the merits of the appeal? And there we will address you really on the following topics. Firstly, that there was no constitutional attack pleaded, and therefore that the High Court judgment was wrong.
Could we just go through it quite carefully, Mr. Tringrove, if you don't mind, just sequentially, because I tried to make the connection, and I'm trying to make the connection now. So could we just go down to, so there's a summary at page 9 of Mr. De Beer's founding affidavit of what the basis of challenge is, and it says summary. So the heading is summary of raised constitutional and other issues. It starts off with saying, the applicants say that she's exercising delegated legislation and that it violates almost every single section contained in the Bill of Rights, but specifically regulating matters which are within the exclusive legislative competence of national or provincial legislatures as intended in the Schedule 5 of the Constitution. So there's a general there's an infringement of the Bill of Rights, and then there is a exclusive competence of particular legislatures, and later on we have a reference to specific legislation. Can we just go on to the end of that with 3.1? In this regard, and by way of reference, I refer this court to inter alia, regulation for the control of business, persons, establishments that sell liquor to the public, funeral parlors, and crematoria. What's the one after that? It says cleansing beaches and amusement facilities. Is that really, I struggled with what that meant. But as I understand it, so right at the beginning, this is what they say. You violated every piece of the Constitution, every fundamental freedom, as it were. And then there's a subcategory.
Sorry, I think that should have been read closing.
Should have read?
Closing beaches and amusement facilities.
Okay, so thanks. But I mean, I just kind of struggled with that again this morning. But could I just ask you this? So at the beginning, there is this at-large contravention of the Bill of Rights, of an impingement on fundamental freedoms. And then they related to particular areas of activity, so the control of business, persons, establishment. So basically a complaint that within all of these categories, there's been a restriction of movement of fundamental freedom. But that's in generalized terms. So that's the beginning. Let's just try and see if we can follow a thread. And then 3.2, then there's a sort of thing that says it's overbroad. It exceeds the purpose and objective because it goes too far. That's as I understand it in generalized terms, is the second. But
that's an ultra-vires challenge, not a constitutional challenge.
No, that's probably correct. But let's go to 3.3. So again, just keep in mind what the basis is. It's this generalized infringement or impingement of fundamental rights. And then there is the ultra-vires or it goes too far point. And then the third one is, well, that's really the National Council of Provinces point. And then the next one is, was irrational and based on incorrect advice and or reaction. So there's an irrationality there that seems to be linked to incorrect advice and a reaction to unconfirmed or otherwise unreliable international and national medical and health results.
Yes, but that seems to be aimed at the declaration of a disaster, not the regulations.
No, that's the declaration per se, as it were, because really what you're doing is all of this isn't really confirmed and you ought to have been a little more careful of what's happened elsewhere.
Bear in mind that in the High Court, Mr. De Beer also attacked the declaration of a disaster. That attack was dismissed and leave to appeal was refused. So that was a discrete issue in the High Court, which is not before you.
Yeah, so what you said, what you're really saying is what you're stuck with is a challenge to regulate the regulations, and we've got to see what that challenge is.
Indeed, yeah.
It's not the declaration of the state of disaster, it's really how you managed it, which ought to be in contention.
Yeah.
So, all right, let's go to 3.5. In the alternative, and in addition to, then there's the prohibition of gatherings. And this really is a complaint that this stifles and really is a complete bar to any protest actions against the government, government's actions in relation to COVID.
Indeed, in conflict with the Gatherings Act.
Yeah. And then they say, this is really, but this impinges, so 3.6 seems to impinge on the state of disaster itself.
Yeah.
Because they say, you haven't considered anything, you haven't considered the alternatives, you haven't looked to see whether you can use other mechanisms or make contingency arrangements. So that implicates the national state of disaster.
Indeed.
If we go to the next, then they suggest that the International Health Regulations Act might be a measure that could have been used. And we'll deal with that and we'll look at that and see if it impinges in any way. And then 3.7, then they say you can only do this when a state of emergency is declared in terms of Section 37 of the Constitution. But then again, that is again a state of disaster contestation, isn't it?
All of that goes to the declaration of a state of disaster.
All right, let's look at 3.8. In the further alternative, the declaration of additional essentials. So this is what you really have done is, you've separated out services that continue to run, and those are essential services, but really you should have left that to the Labour Relations Act and the mechanisms thereon. Then 3.9, mining sector. I struggle to understand this, but it seems to me that you've allowed some people to go back. You haven't allowed you've allowed some professions to continue. You really are exposing people in particular forms of industry or particular categories of industry, which is high risk to continue. And you're inconsistent in a sense that you're allowing people on taxis, but you're not allowing people at funerals. So all of that seems to be included in that. Am I correct in that, or is there another?
It is scattergun, but that is right, yeah.
And then 3.210, which is, I think this is a theme that keeps on recurring, that legal, financial, and property property industries, and I think the property industries come up regularly, and hair and beauty salons. So he's really concerned about the impact on those as being affected operations that aren't to continue. And then in general, so the last one is back to an in general. So let's figure out. So far up until then, we have a sort of attack on the basis that it infringes a whole lot of personal freedoms. None of the particular regulations in point are itemized. I can't find those itemizations. And then there is all of this other stuff, which we've now gone through, which is an attack, I think, on the national state of disaster itself, and whether or not other contingencies are to be ought to have been taken into account, and that it's overbroad. And then all of these other industries that have been detrimentally affected. That's, as far as I understand, the sort of summarized bases of the attack. Then they go to essential facts. So do you want to address each one of those as he does it in conjunction with what these essential facts are, and what you say are the shortcomings?
Let me say, in fairness to Mr. De Beer, just point to two further complaints he raised under the Bill of Rights. The one was the last paragraph that you mentioned, 3.11, where he says, in general, these regulations have violated almost all clauses in the Bill of Rights of most of our citizens, etc. And then to the same effect, much later, at page 31, in paragraph 10, he says, we specifically challenge the right of the minister to have implemented law which had extensively violated the Bill of Rights. So the high watermark of his attack is that all of the regulations, or many regulations, violate many provisions of the Bill of Rights. Nothing specific. He never says this regulation violates that right for this reason. I mean, take for instance one of the regulations that the High Court eventually struck down, the ban on night vigils. Now, what was there to tell the minister that she had to justify the prohibition of night vigilance? There was nothing in there to do so. The prohibition, another prohibition of exercise before 6 or after 6 in the afternoon. There is nothing in there to tell the minister that that regulation is under attack and what the reasons for that attack was. So you, with respect, when one contends that a law is unconstitutional, then you have to identify the particular law. You have to identify the constitutional right which it violates, and you have to explain why there is a violation, so that the minister must have enough information in order to defend the law. This shotgun approach did not tell the minister that this regulation is being challenged under that provision of the Constitution for this reason. So there really was a blunderbuss approach which did not give the minister sufficient information to make an active or realistic defense. And let me say this too, that not even Mr. De Beer before you argues that there was a proper pleading, both a nationality pleading or a Bill of Rights pleading. He deals with it in his heads of argument. On a rationality attack, he deals with it in paragraphs 6.3 to 6.5. And on the Bill of Rights attack, he deals with it in paragraphs 6.6 to 6.9. Now, in neither case does Mr. De Beer say that he made a proper attack, that he pleaded a proper attack. Mr. De Beer's approach, much like the High Court's approach later, is this. He says, well, I challenged the minister on the rationality and on the Bill of Rights. And the premise of his attack is this. He says, in effect, that what the Constitution requires the minister to do is before she makes regulations, to do an audit of the rationality of the regulations and of their Bill of Rights compliance. And so that when they are challenged, what the minister is required to do is, as it were, to produce her audit work papers for the court then to verify whether or not she had properly considered rationality and Bill of Rights compliance before promulgating the regulations.
Well, do you accept that in a response, well, I mean, it's a bit of a chicken and egg situation. Depends on what's pleaded and how you have to respond to that. But in your response, I would assume that at the very least you've got to show that you're within the parameters of Section 27, that the basis of the declaration, you have to at least show that.
But let me say, the Section 20, the ultra vires attack was dismissed and is not before you. So what you're left with is the High Court's causes of action which it upheld, which is rationality and Bill of Rights. And I'll go to them shortly because the High Court misconceived both those standards. But they were the surviving standards upheld by the High Court. But on neither of those two causes of action, nor rationality, nor Bill of Rights, was pleaded in any way which allowed the minister to defend the regulation.
Let me put it differently, Mr. Tringrove. So she'd have to say, well, as she would, I declared a state of disaster. It's within these parameters that I've done so. Yeah. And then she's got to say, the regulations I have made pursuant to that state of disaster fall within these categories and are to achieve the objects of the Act. She's got to at least get, that's at least that's first base. She's got to get past that.
Well, as a matter of law, her regulations have to comply with those provisions. But as a matter of review, it is incumbent on an applicant to challenge the regulation either on an ultra vires basis or on the basis that it's irrational or on the basis that it violates a provision of the Bill of Rights. But in each instance, with sufficient particularity of the attack to enable the minister to defend her regulation. The law does not require the minister to assume an onus of proving the validity, intra vires, rational, and compliance with Bill of Rights as a matter of pleading. It is for the party attacking the legislation to make a case of ultra vires or irrational or violation of the Bill of Rights. And that must be done with sufficient specificity as is necessary to enable the minister to make a rational response. But let me also just say this, that what then happened was that the new regulations, the new level 3 regulations, were promulgated, as luck would have it, on the date of the hearing before the High Court. So they were not, as a matter of fact, before the court when the debate took place. There were reports of the new regulations, and people knew that...
Well, there is that exchange. Well, there is, the judgment is that there was an exchange with counsel for the minister at that stage that resulted in them being considered. And then there's a transcript of what occurred.
Yeah.
But it does seem to me that if, going back to your particularity claim and your pleadings case, that whatever counsel says in the exchange, and let's assume for the moment, let's just assume for the moment that the exchange with counsel is the one that the judge describes. Just assume that for the moment. But surely in the founding papers, there's then got to be an attack on those regulations that supplant the old ones. It's got to be pleaded.
Absolutely, you can't buy. I accept that there was a misunderstanding between judge and counsel. Counsel certainly never suggested that the minister agreed that a challenge be considered against the new regulations which nobody had seen. But even if that were the judge's understanding, with the greatest of respect, it is not within the competence of counsel to shift the debate, the issue before the court, to an entirely new set of regulations which weren't before the court when the debate was had at all. And in fact, again, with the greatest of respect to the learned judge, just to imagine what happened in this case. The judge goes home after the hearing, gets a copy of the new regulations, the new level 3 regulations, completely new set of regulations. Some of them repeat old regulations, some of them replace them, some of them delete them, but it's a new set altogether. The learned judge then sits down and reads them and picks out 6 which he thinks look irrational to him. He then So he firstly takes it upon himself to identify the 6 regulations. He takes it upon himself to articulate the flaw in the regulations. And he then upholds that contention that they are flawed without any input from anybody, without a pleading by the applicants, without a defense by the minister, without a debate in court about the legitimacy of the attack. That is, with the greatest of respect, a fundamental failure of audi alteram partem, and therefore a violation of Section 34 of the Constitution. One can take each one of those 6 regulations which he held to be irrational and ask yourself, well, you say that the ban on night vigils is irrational. You haven't asked the minister why she imposed that ban. What do you know about night vigils? Have you ever been to one? Can a judge take judicial notice of the circumstances at a night vigil? Should you not allow the minister to explain to you why night vigils are pose a COVID risk? These are merely simplistic but stark illustrations of the massive failure of audi alteram partem. We submit with respect that it was a fundamental flaw. And then it went one step further. Having found 6 of the regulations to be, let me say of the irrationality of the 6 regulations, the learned judge misconceived the rationality test, because in most of those cases, what he did was not to ask himself the rationality question, i.e., does this regulation, is there a rational connection between the regulation and its purpose? In other words, does the regulation in some way advance a legitimate purpose? He applied a different test. He said, why ban hairdressers when you allow taxi operators, a comparative one, a what about argument. But that's not a rationality argument. There might be an equality argument, there might be some other argument, but what about somebody else is not a rationality test. And if he in fact then conflated rationality and Bill of Rights, in that he ultimately concluded that because the regulations were irrational, therefore they were not a justified limitation of the Bill of Rights. But having concluded that these 6 regulations were unconstitutional, the learned judge then struck down all of the regulations, not only level 3 regulations, but all of the regulations from beginning to end, because he said there were multiple further examples of irrationality. And that, with respect, simply highlights the irregularity of the process that was followed for the judge to assume jurisdiction, to sit in judgment on regulations and on causes of action which had never been pleaded before him. If I may refer to just some paragraphs of the judgment. I may start with paragraph 7.1. That is at page 355. It is in paragraph 7.1 to 7.10 where he makes the rationality assessment of the 6 regulations that he's picked up, the 6 of the new regulations that he's picked up. And I won't take you through all of them, but they are, by and large, a debate about irrationality in the judge's sense, i.e., why ban this if you allow that?
Well, that's the part I'm trying to understand, because if you look at 358 and you look at the conclusions, and he really talks about disparities, he's really comparing what he says are different situations.
Yeah.
I mean, in Mr. De Beer's affidavit, there are generalities, and there may be some of those there may be some generalities in the minister's answering affidavit as well. But where does he? I mean, surely when you're dealing with those disparities, you've got to say, well, let me look at them. Let me consider whether or not those disparities are meaningful. Let's consider whether they're justifiable. Let's look at whether the parties have joined issue on those aspects.
Yeah. And you must first ask yourself, well, firstly, he argues the trend of the argument, the logic of the argument is that these regulations are overkill. You've gone further than is necessary for reasonable regulation. Or why so stringent here and so forgiving there? Why hairdressers and not taxi operators? But that perspective, as I've submitted, is not the proper rationality test.
And Mr. Trentproof, also ignoring the provisions of Section 27.2, particularly 27.2N, which gives quite wide powers on the minister, like other steps that may be necessary to prevent an escalation of the disaster or to alleviate, contain, and minimize the effects of the disaster.
No, that's absolutely so, with respect, Justice Mbata. But that's because his lordship, I think, was confused about the proper test. He purported to apply a rationality test, but in fact did not apply the correct rationality test.
Well, could you go to page 362 of the record 7.14? What do you make of that? He then tends to, so he's sort of dealt with some regulations, and he says, despite the failures of the rationality test in so many instances, there are regulations which pass muster. And then he deals with cautionary regulations relating to education, prohibitions against evictions, initiation practices, and the closure of night clubs and fitness centres. All appear to be rationally connected to the stated objectives. What do you make of that as opposed to...
Well, he ultimately excludes a few regulations from his general order of invalidity, and I think this part of his judgment explains why some of them have been excluded. But if you take a step back, just a step back to paragraph 7.13, after concluding that his 6 chosen regulations are all irrational, he says in 7.13, I'm certain from what I've seen in the papers filed in this matter and from a mere reading of the regulations, even including the alert level 3 regulations, that there are many more instances of sheer irrationality included therein. So there's a sort of a general condemnation beyond the 6 regulations. Then he goes on to explain that there are a few that he's identified as rational. And then he gets to 7.16, where he says, I debated with counsel for the minister the fact that I failed to find any evidence on the papers that the minister has at any time considered the limitations occasioned by each of the regulations as they were promulgated on the constitutional rights of people. The Director General's affidavit contains mere platitudes in a generalized fashion in this regard, but nothing of substance. So, having condemned them on the grounds of rationality. He now turns to the Bill of Rights, and he finds that they violate the Bill of Rights on the basis of the lack of evidence of justification. But it is to put the onus on the minister to prove compliance with the Bill of Rights in the absence of a coherent and specified Bill of Rights attack. And it is ironic that the judge, in his own terms, upholds a Bill of Rights attack purely because of the complete absence of evidence on record about compliance with the Bill of Rights.
Mr. Trengrove, you broke up for a few seconds. Could you just repeat that?
Can you hear me now, Justice Nelson?
Yes.
What I'm saying is that it's ironic that the learned judge seems to uphold a Bill of Rights attack purely on the basis of the absence of evidence on justification under the Bill of Rights. But there is an absence of evidence on the issue because the issue was never coherently pleaded. The absence of evidence is a symptom of the fact that there is no coherent Bill of Rights attack pleaded at all. And the learned judge makes that clear in the following paragraph. The clear inference I draw from the evidence, i.e. the lack of evidence, is that once the minister had declared a national state of disaster, and once the goal was to flatten the curve by way of retarding or limiting the spread of the virus, all very commendable and necessary objectives, little or in fact no regard was given to the extent of the impact of individual regulations on the constitutional rights of people and whether the extent of the limitations of their rights was justifiable or not. That is a manifestation of what I've described to you as Mr. De Beer's attitude that says the Constitution requires of the minister to do a Bill of Rights audit before she makes regulations. And the fact that there are no audit papers before me justifies my inference that she failed in her constitutional obligation to audit her regulations for compliance with the Bill of Rights before she promulgated them. But that is, of course, to get things back to front. A wise minister would always, of course, do a Bill of Rights audit before issuing regulations. But the issue before the court is not a process issue. The issue before the court is whether the outcome, the regulations, the substantive outcome, whether they comply with the Bill of Rights or not. And there was never a cause of action pleaded to the effect that they violate the Bill of Rights in specified respects. And then comes the conclusion in paragraph 7.21. Where the Lordship says, I find that in an overwhelming number of instances, the minister have not demonstrated, i.e. proof is on the minister, that the limitation of the constitutional right already mentioned have been justified in the extent of Section 36 of the Constitution. That's again the absence of evidence is what the court holds is fatal. But the absence of evidence is relevant only if there is a coherently pleaded cause of action, which with respect there was not. So that we submit with respect that there was no proper irrationality attack pleaded. There was no proper Bill of Rights attack pleaded. But then regardless of the adequacy of the pleading, the learned judge committed a fundamental breach of the Aria Alteram Partem rule by shifting the debate to the new regulations which were not before the court at all.
Mr. Trengrove, at least one or two passages in this judgment seem to rely on a proportionality, argument,
yes,
which says the means that you took to achieve the end were too harsh.
Yes.
Just illustratively, paragraph 7.5 of the judgment appears to be such a case.
Yes.
You could have allowed for cultural observances by way of vigils and the like with some greater respect for cultural norms and achieved the same result. That seems it's a sort of invocation of proportionality under the guise of a rationality challenge.
Yes.
Can the rationality threshold be debated in terms of proportionality?
With respect not, the two are different things, and I regret to do it to my learned friend, Mr. Budlander, but they have a wonderful expression in their heads of argument, which if I may plagiarize it. They say to use a sledgehammer to kill a gnat might be disproportionate, but it's not irrational. And that is with respect what the learned judge did, is that he did not distinguish between rationality on the one hand and proportionality on the other. I'm not suggesting that a proportionality debate is irrelevant. Certainly, these regulations, if and when they impinge upon fundamental rights, then the limitation triggers a limitations inquiry, which is a proportionality inquiry. But none of that can happen coherently unless there is a coherent cause of action pleaded of a particular regulation which limits a particular constitutional right and therefore calls for justification.
Yes, so you are with Mr. Budlander on the proposition that proportionality is a limitation exercise. It's not a rationality exercise.
No.
Is it not at least conceivable that a rule of law argument could be made, quite apart from the Bill of Rights, to say that actually it is arbitrary to use a sledgehammer when something less could be used when you're dealing with this kind of legislation?
Well, let me say that...
not saying that case was made, but since under the broad rubric of rationality, does proportionality only figure in limitation?
Let me say this. If the means impinge upon fundamental rights, then of course it raises a justification and a proportionality question. But if the means do not impinge upon fundamental rights at all, then the only question is one of rationality. And then the only question is, do the means advance the end? Does the sledgehammer kill the gnat? And I appreciate, and I submit then, that it passes muster under the rationality test. And if there are if the means do not involve any limitation of any fundamental right, then that's the end of the matter. Because gnats don't have fundamental rights, I suppose. So we submit with respect that the judgment was fundamentally flawed because no attack was pleaded, and then because the learned judge shifted completely out of the pleadings into the new set of regulations without any justification. We also do lastly complain that the orders are unduly vague. The order, of course, striking down all of the regulations is very clear, but he then required the minister to reconsider and republish or repromulgate the orders and to report back to the court.
Well, it's almost in the form of a supervisory order, and I'm not quite sure that that's the job. The job really should be, you've made if it's justified, you've made a mess. I'm giving you until such time to fix it.
Yeah,
that's the conventional form, because then you can, and really it's a separation of powers issue. It's a question of, but you can't. And if you're going to do a supervisory order, shouldn't you do a supervisory order that's capable of supervision, as it were? I mean, what are you doing? Are you preempting a second review at your own instance? I'm not quite sure how you do it.
Yeah, and what's more, it's one thing to say to a minister, and with respect, the comity between the judicial branch and the executive comes into play here. And I submit with the greatest of respect that the learned judge crossed that line. It's one thing to say to the executive, your regulation is invalid, I afford you an opportunity to fix it. That's the conventional rule. What this learned judge did was not merely to afford the minister an opportunity. He ordered the minister to redo all the regulations and then to report back to him on the doing of it. I'm not quite sure what she was meant to report, but
what do you do subsequently? I mean, if the minister reports back and you don't like those regulations, do you do a review of your own mero motu?
yeah, and how do you make sure that the judge won't tick you off again? What is it that you have to do to satisfy the judge? Listen to the order, it's paragraph 2. The declaration of invalidity is suspended until such time as the minister, after consultation with the relevant cabinet ministers, review, amend, and republish the regulations mentioned above, excluding certain regulations, with due consideration to the limitation each regulation has had on the rights guaranteed in the Bill of Rights. And then he goes on to say, and the minister must report on...
Well, let me ask you this. Paragraph 2 on its own is unobjectionable because it's a bit more embroidered than usual. But one would expect that when you give them an opportunity to fix it, there's an expectation that they'll do it properly this time. But that's for them to decide, and that's for them to do. So 2 on its own is hardly objectionable on its own.
No, I submit with respect. It's not an opportunity given to the minister. The minister is ordered to do something.
Yes.
And the question is, what does the minister have to do to comply with the order? And I suppose the minister could take a chance and say, I'll do my best. But how does one judge whether what the minister has done is to review, amend, and republish in a way that satisfies the court order, particularly because she's then required to report to the judge how she's gone about it?
Well, that part I can understand. But ordinarily, when you give an opportunity to fix, it's on the assumption whether or not it's policeable subsequently by the same court is a different question. But it's done on the assumption that you've told them it's wrong. And if there's a coherent judgment on which there's a rationale, they'll conceivably take that into account when they reformulate it. But that's what you give them an opportunity to do, or you order them to do that. But that is not objectionable. It's how you deal with it subsequently. It's what do you do with it subsequently?
Well, I submit with respect, this is not an opportunity. It's an order that the minister does something. And the question is whether it is sufficiently specific to allow the minister with confidence to know what it is that she has to do to satisfy the court order.
Okay.
We've had one application for imprisonment.
I just wanted to add a comment following upon my brother presider. That's why I think Mr. De Beer all along thought that this was an interim order. It's a supervisory order. All along he's been saying this was an interim order. The order was not a final one because of the nature, the way that it is couched.
Yeah, Justice Mbata, that is so. That is what Mr. De Beer has on occasion said. He's on other occasions said that the minister should be imprisoned for contempt of court because she didn't comply with the order. But you're right, those are some of the contentions that he's advanced.
So, Trengo, isn't the problem with the second order that the lack of precision in the judgment as to precisely either on rationality or Bill of Rights grounds with each regulation means that the minister doesn't know what to do? I mean, doesn't know what the court has in mind as the problem.
Yeah, no, exactly. It's it doesn't. You remember that clause, that the provision where the judge said, and there are many other provisions which are similarly irrational, and the judge then strikes down all of them. So that there's no guide to the minister as to what she has to do to satisfy the judge. Remember, the minister thinks that these regulations were duly and properly and lawfully and constitutionally published in the first place. There's only the judge who tells her that she was wrong. Well, then she needs to know what she has to do in order to fix it.
Well, I suppose from the perspective of the minister, there's a lack of clarity in the reasoning, lack of certainty in the order. When exactly, how is the minister supposed to comply, and when exactly is the minister in danger of being in contempt?
Indeed, that is the problem. But let me also say that the vagueness problem is the least of her problems. It's a real problem, but the fundamental failure of Audi is really what brought about the injustice in this case.
Yeah, and and if one were to be with you on that score, namely that the judge in the court below appropriated to himself the right to decide issues that had not been properly raised and fully ventilated, is that not necessarily dispositive of the matter?
Oh, absolutely. And you'll recall a judgment of this court of His Lordship Mr. Justice Harams in NDPP v. Zuma, where he sat in judgment of on appeal of a judgment by His Lordship Mr. Justice Nicholson.
Yes.
Where that same point was very vividly and very emphatically made. And we submit that this judgment suffers the same fault.
Yes, thank you.
Sorry, Justice Nafsa, can I just... I think, Mr. Tringo, are you about to hand over to your colleague?
I am, yeah.
Can I then just ask this section, the regulation making power in section 27.2 is made subject to 27.3. And 27.3 states the powers referred to in subsection 2 may be exercised only to the extent that this is necessary and then for various purposes. Now, that formulation is not expressed as in the opinion of the minister. In the full court, you'll be, I think it was the fair trade case, they said that meant reasonably necessary, not strictly necessary. Accepting that it means reasonably necessary, do you accept that it posits an objective test?
Yes, we do.
Which puzzle me. I don't want anything we write in this case to perhaps misunderstand. For some reason, the whole case, or one half of it, became focused on the rationality of the regulations. If it had been assessed on the question whether, objectively speaking, a matter justiciable by the court, the regulations were reasonably necessary, it would have been the bar that the minister had to overcome would have been higher than a mere rationality challenge.
Indeed. But again, that inquiry would be a pure fact-centered inquiry.
And it would require a pleading directed at specific regulations and stating why that one wasn't necessary for one of the permitted purposes.
Yes. But the starting point for that debate would again have to be one that says Regulation 7.2 is not reasonably necessary for any of the authorized purposes and is for that reason invalid. It's then for the minister to
put up her evidence.
To put up the evidence as to why it is necessary. And that inquiry is a fact-based inquiry. It's not one that one can do in the air.
Well, it's really, in an assessment, Mr. Tringrove, you've got to start with the declaration of the state of disaster. It seems that that's the beginning. If you don't attack that, because that has to have an underlying rationale and an underlying basis, and it has to be constitutional, it has to comply with whatever the Act says. So you've got to start there. Once you've got that, that's the foundation. Everything else that's done subsequent. So objectively, you'd start off with there have to be factors which objectively justify the declaration. You then to the second leg. And the second leg would be, we now all agree, let's just assume that for the moment, notionally. We've got the best experts in the world, at least notionally. And I'll take you, there's one part I do want to concentrate on a little later. But you then look at what I think what could be done in terms of these provisions of the Act to enable me to attain its objects. The object would be to deal with the state of disaster and to minimize the threat posed by the disaster. I then go through a checklist of where you talked about an audit that they require. But certainly if I was the minister and I was making regulations, I'd look at the powers within which I have to operate, and I'd see if I'm acting within those powers, and that those powers are all consistent with dealing with the threat posed by the national state of disaster. It must be.
No, absolutely. Well, and I mean, not only is that coincidentally so, but you know that the Act has been open to challenge for being so drastic and invasive, so that those objective jurisdictional requirements are important because they ameliorate the drastic invasive powers conferred by the Act.
Well, isn't part of the problem in the pleading is that there's a skirting between, and I really just want to take you to the whole, sort of, if we could go to page 23. And it may be this, because we dealt with whether or not there was in effect a challenge to the state of disaster. If you go to what's itemized from, say, 6.7, 6.8, 6.9, and then perhaps more vividly, that is 6.14 on page 25. Is there a flirting? Because as I understood, one of the things that were proposed to us as to why we shouldn't be hearing this virtually, because one of the issues is whether or not COVID-19 is what COVID-19 is. At least there's a suggestion. Is the problem? And if I'm doing, I'm asking you not as someone propounding the minister's case, but just to see whether or not I'm missing something, or whether I've misconceived this. Is there a flirting with COVID denialism there?
No, absolutely. No, it's not a flirting, it's an embrace of COVID denialism. You'll see in these heads of argument, he also wants you to call it an alleged pandemic, not an actual one. But that was foundational to the attack on the declaration of a disaster in the High Court, and that attack has been discussed.
Isn't that part of the problem? That it's and that's really what I was struggling with when I read through the finding. It would seem to me, if that's your position, if your position is, hang on, this is just all nonsense. It's just created. It's no different from the flu. But then the attack should really be on whether or not there should have been a state of disaster, because it's no different from the flu. If it isn't very different, if the statistics aren't persuasive, then why are you having it at all?
No, you come in at the end of this case. The case in its earlier form was, in the first place, a full frontal attack on the declaration of a state of disaster on a variety of bases, one of which is that COVID isn't COVID. But yes, that was fundamental to the case as previously presented. And that was also, remember, Mr. De Beer was denied leave to appeal, and he pursued it. This has constitutional court proceedings on the go. He applied for leave to appeal to the Constitutional Court. It was refused, and he's brought a rescission application in the Constitutional Court to have that refusal overturned.
The Constitutional Court's decision.
Yeah, the Constitutional Court refused him leave to appeal. He tried to appeal, though, the dismissal of his application directed at the declaration of a state of disaster. He was refused leave to appeal all along. He applied to the Constitutional Court. It dismissed the application for leave to appeal. He's now applying for rescission of the Constitutional Court order dismissing his application for leave to appeal. So that's a very prominent part of the case, but one that you have been spared.
All right. So are you ready to hand over to Ms. Hassan?
Yes, I am. Thank you, Justice Napsa.
Ms. Hassan.
May it please the court, Justice Nafsa, justices of the court, there's one preliminary issue that remains outstanding, and that's in relation to the condonation application that's been brought on behalf of the minister. It relates to the preliminary point by Mr. De Beer that because the minister failed to file a second notice of appeal, those issues that were excluded from his lordship, Mr. Justice Davis's leave to appeal order, the 6 regulations that is, do not form a part of this appeal. They should be precluded from this appeal on the basis of non-compliance with Rule 7.1b of this court's rules. If I may just deal with the background to the application for condonation. It was brought on the 23rd of December 2020 by the minister. The affidavit was supported, deposed to by the state attorney, Mr. Zulu. And the background was this. The minister had brought the application for leave to appeal before his lordship, Mr. Justice Davis, against the whole of his judgment and order that was made on the 2nd of June. His lordship granted leave to appeal in part and refused leave to appeal specifically in relation to the 6 regulations that he referred to in paragraph 2 of the order in the leave to appeal. A Rule 7.1a notice was then filed with this court. That is where, for the aspects on which leave was granted. A special application for leave to appeal was then filed in respect of the 6 regulations. And on 11 September 2020, Justices Nichols and van der Merwe granted leave to appeal. What then ought to have happened was that a second notice of appeal in accordance with Rule 7.1b should have been filed. The minister failed to do so. Mr. Zulu explains that although the notice had been filed in terms of Rule 7.1a, it was a complete and unintended oversight that the second notice of appeal had not been filed. And this was a regrettable oversight. It was not intended to indicate that the minister was not pursuing that aspect of the appeal or indeed any disrespect with the rules of the court. The second...
Sorry, in the heads that were filed, it wasn't excluded.
It was not excluded. So that's absolutely right. On the 4th of November, 2020, when the heads of argument were filed on behalf of the minister, the issue of the 6 regulations was squarely addressed. And in fact, in paragraph 17 and 18 of the heads of argument, it was made clear that we've received we've been granted leave to appeal by the SCA in relation to the 6 regulations, and that the appeal, therefore, is in relation to the entire judgment and order of his lordship, Mr. Justice Davis. We made that clear in the heads of argument and in the practice note. So there was never any doubt as to the minister pursuing that aspect of the appeal. In our view, and in line with the test, which I need not repeat for this court, on the principles of condonation, there are two key issues. The first is that there's a live appeal before this court. It was made clear, although not through a Rule 7.1b notice, it was made clear in other forms that the minister is actively pursuing her appeal in relation to the whole order. And in fact, the respondent in his heads of argument addressed those grounds of appeal. So there's no prejudice to the respondents in this matter in relation to the 6 regulations at all.
I noticed that the notice of appeal that was in fact filed timeously on the 10th of July, this is at volume 3, page 406 and 7, perhaps somewhat presumptuously asked that the appeal be upheld and the order of the High Court is substituted with an order that the application is dismissed. So that notice of appeal in fact sought the relief that would have been sought if you had leave on all grounds.
All grounds, indeed, Justice Rogers. And this is, again, consistent with the approach that had been taken by the minister. There was never a doubt about what was intended. The second issue, and we would ask the court to consider in considering condemnation, is the prospects of success on appeal. These 6 regulations, which my learned senior has already addressed at some length, the validity of those 6 regulations raise important issues, not only in relation to the validity of the disaster regulations as a whole, but also in relation to the appropriate application of the test for rationality and the limitations clause. And the most fundamental error that has occurred with respect in the High Court is that the court had regard to the 6 regulations even though they had not been placed before the court. And that much is recorded in the judgment at paragraph 7.15 of the judgment, where the judge notes that those regulations had not been placed before him. So neither the court nor the legal... My apologies, Justice Nafsa, you're on mute.
Sorry. There's no doubt about the extent of that order. The real question is whether or not you technically did everything that was necessary to deal with it.
That is correct.
All right.
That is correct.
Well, so you're saying they knew all along that there was an oversight. You accept that there's an oversight. You say they knew that there was this. There can't be any prejudice. In any event, everything is all in the mix, and therefore condemnation should be granted. Is your argument much more than that?
That is the extent of our submissions on the condemnation. Thank you, Justice Nafsa.
All right. Mr. Budlender is up next.
May it please the court. In the light of the debate which has gone before, I will be brief. There are 2 principal submissions which I wish to make on behalf of CAPITEC, and they both flow from CAPITEC's commitment to promote democratic and effective and transformative government in which the courts are guardians of the Constitution and the rule of law. The first point is about the nature of administrative law. It's a broad point. It's now nearly 40 years since Professor Baxter explained to us what administrative law is about. If I can read from page 3 of his book, he says of administrative law it stipulates a set of common principles which are designed to promote the effective use of administrative power, to protect individuals and organizations from its misuse, to preserve a balance of fairness between public authorities and those with whom they interact, and to ensure the maintenance of the public interest. In other words, administrative law is not about a set of judicial tripwires in which courts search anxiously for reasons to overturn administrative action. It's about enabling effective government under law in accordance with our Constitution. And that understanding with respect is lacking from the judgment of the High Court. The second point really flows from the first. It's that the judgment of the High Court, unfortunately, actually undermines the role of the courts in holding power to account. And the reason for this is the following. Why he makes this submission is the following. As we all know, it has become fashionable in some circles these days to complain of judicial overreach. Usually, the complaint is usually made by people whose real complaint is that the courts are doing what the Constitution requires them to do. But this is a case of true judicial overreach, which undermines the function of the courts.
Could I ask you this? I struggled as I read through the founding affidavit to understand what the parameters of the case were, because there are large parts that deal with, and I think probably everybody of reasonable measure accepts that internationally, and it's not about taking judicial notice of notorious facts. The real point is that I think we all accept that internationally the poor and the vulnerable are really at the coalface of having to deal with the restrictions that are imposed. So employee restrictions, operations of hotels and everything. I think we all accept that. what I struggled with is, in a sense, we were told about all of the cases of tenants who've been evicted, of landlords behaving badly, of people losing their jobs. And then we have the sort of thing about COVID. Now, it would seem to me you've either got to challenge at the coalface, you've got to challenge the state of disaster, the declaration of a state of disaster, if that's your complaint. Or if that's not your complaint, and your complaint is that the measures are such that they affect particular categories, that you then itemize it and then say, well, can I just show you regulation so-and-so deals with this category of professional occupation or employee class or industry. And I'll tell you why it's bad. It's bad because this has happened. These are the facts. And I'll tell you what you could have done if that's the challenge. If the challenge is against the declaration of the state of disaster, and I don't know that a judge of my generation would not be concerned about the impact on poor and vulnerable people. So that's a given. The question is how you deal with it. And you heard Mr. Trengrove make the submissions concerning the pleadings. Well, let's assume for the moment, just for argument's sake, that the pleadings weren't a model of clarity and specificity. Let's just accept that for the moment. Surely the judge should then have dealt with it on that basis, or the judge in the court below should have said, well, hang on, I've looked at all of these things, and I have particular concerns about how all of this has been done, but I don't know that the minister has been called to account specifically and why in respect of a particular field of activity, endeavor, or particular groups, the minister has done this. And that's the difficulty here. It just seems to me, and when I talked about those passages that do they skirt with or do they actually attack COVID as a phenomenon? Is it COVID denial? So let's be clear, Mr. Badlinda, no one on this court, not one of my colleagues, is not concerned about the impact on poor people. That we see that around us. You don't have to be you don't have to gaze into a crystal ball. You can see what's happening and you can see the effect it'll have on the economy and poor people. The point, though, is you've got to start working out what this case is about, how it's been drafted, how it's been pleaded to. If the minister's response was woeful, well, then that's something to be taken into account. So take into account what Baxter has said. You look at what the challenge is. You look to see whether the minister has responded to that in an accountable fashion. And then you figure out whether the court has done its business at court of first instance. So I'm just putting that out there for you to respond to in furtherance of your argument about Baxter and what you think the court below has done.
Yes, Justice No. So the starting point, as always, has to be facts. I always remember what I was taught by someone who taught both of us, who said the law follows the facts. Get the facts on the table first, and the courts will see you right. But you don't start with assertions and conclusions without facts. If facts have been alleged, this is what has happened to people, here's some evidence, then the minister would presumably have dealt with it. And if she hadn't dealt with it, she would have been in difficulty. But these broad-ranging assertions, which are really all conclusory statements, they're not facts. They're conclusory statements that people's rights have been infringed, without any facts to justify them, have unfortunately become a large part of the litigation which we see these days, in which wild and wide-ranging allegations, conclusions are stated, and courts are then asked to determine the law on the basis of those conclusions. That, with respect, is not how we do it.
Sorry, Mr. Badlinda, there are two linked concerns. The first is that there aren't any confirmatory affidavits. Accepting that this was an urgent application and making allowance for that, that still raises feelings of disquiet. But there is a further concern, and that is all of these annexures to the papers. Now, it wasn't exactly clear to me what the evidential weight of these annexures was supposed to have been. Now, if you say X and you put up an annexure as proof of sort of X, then that's fine. If you were to say there is such a report here's the report, and you put it up as proof of the existence of the report, that's well and good. But there would still be a concern about the admissibility of the truth of the content of that report. Now, and that's part of the problem that one finds, particularly with the founding affidavit in this case. I mean, there are any number of reports, and these are just annexed to the papers without so much as by your leave, or here's the explanation for this. There's attempts every now and then in the founding affidavits to refer, for example, the deponent refers to his particular expertise. It's not exactly clear to me what that is supposed to be. And then on the strength of that, you've then got a whole lot of opinion evidence as well.
Yes, it's Justice Punnan. This is a classic Swissborough case in which a whole lot of stuff is thrown into annexures, and the deponent or the applicant hopes that there'll be something in there which it can rely upon when the case comes to be argued, and what one's to make of it is unclear. And of course, it's piled high with hearsay. Of course, sometimes hearsay is necessary, but then you make out a case as to why hearsay is necessary. But this is really just throwing a bundle of stuff at the courts and saying, now you sort it out. And unfortunately, with due respect to the learned judge, he was panicked by it. That's the only conclusion one can reach. He was hearing an urgent application. He was worried about it. He was so worried about it that he went home and read the new regulations and made his own decision about which were valid and which weren't. And he didn't do with respect one would require of a judge to say, hang on a minute, let's just see what the evidence is. Let's just deal with what's before me. And if you've got another case about other things, bring that other case. Don't expect me to deal with that in this case. But unfortunately, it's a sort of moral panic which sometimes infects the situation. So we submit, we've made the submissions in our heads, and I'm not going to repeat it all, that the judge, with respect, got the fundamental principles of administrative law wrong, confusing irrationality with proportionality, and that's been dealt with, and I'm not going to go there. It's sufficient for me to say that these issues were dealt with by the subsequent judgment of this court in the Esau case, which was decided in, I think, December last year, in which this court dealt separately with justifications, analysis, and rationality, and separately with reasonableness. And it didn't merge them into one hodgepodge of complaints and say, well, this is reasonable, unreasonable, and or disproportionate, therefore it's irrational. That really doesn't cut it.
Mr. Budlinder, I accept that if you're testing one particular regulation, you don't demonstrate its irrationality by pointing to the fact that another case, which you might have expected to be dealt with similarly, wasn't. In other words, on a comparison basis. But what do you say to Justice Unterholter's question to Mr. Trengove, which would, if I can rephrase it, widespread irrational distinctions in administrative action, whether regulations or some other form, might be evidence of arbitrary or capricious action, and that it might be properly pleaded, that is. It might be a legality challenge. You might not say exactly that it's an irrationality challenge, but pharmaceuticals, as I understood it, still accepts as a basic premise for legality the old Shediac grounds of arbitrary and capricious. And if one finds administrative action thoroughly infected with irrational distinctions, one might end up saying that doesn't pass the legality test. I just wouldn't want anything we say in this case necessarily to show that irrational distinctions are irrelevant when assessing a legality challenge.
Yes, Justice Rogers, I with respect don't disagree with that. I think the problem arises from the use of the word irrationality, because we use it colloquially, irrational distinctions, as you've referred to. That's how we use the language. But that then morphs into an irrationality challenge, which isn't justified. I accept that if there were distinctions drawn which can't be explained on any sensible basis, then one might say, well, this is arbitrary. And arbitrariness, I accept, is a ground on arbitrariness is inconsistent with the rule of law, and it founds a legality challenge. The problem is the irrational is used in two different senses. One, irrationality in the sense used by the courts in determining legality. Namely, is it related to the purpose for which it's intended? And the other is there some sense in what has been done? But I do accept, with respect, that arbitrariness is a ground for review. Of course, one always has the difficulty in arbitrariness when you say, why did you do A and not do B, which is on a par? Then the question becomes, well, now what? Do we say A must be struck out or B must be added?
Well, isn't that usually drawn in relation to unreasonableness? What is more reasonable, this or the other? That's not for you to interrogate. But, going back to Shidyak and union government and arbitrariness, I would expect that if you were doing the rationality test for legality, for example, and really, I think everything turns on what was pleaded and what the facts are on which we have to decide matters. But when you test for rationality, then you really look to, is it intended for purpose, as it were? The point, though, is arbitrariness is almost at odds with that, and I'm not sure that the two don't flow together. But it hardly matters, because what you've got to do is you've got to look at what the complaint is, whether it's a rationality complaint, and what is the substratum of that complaint. I also have thought that there's got to be a overlap in that unfounded discrimination is also irrational. Unfounded discrimination in colloquially or semantically. Unfounded discrimination would seem to me to be an arbitrary, would be, if you can't say why I've done X, and we know our sort of discrimination cases that have been decided in relation to particular classes and stuff like that. But I don't know that one needs to interrogate all of those things to the umpteenth degree. In this case, you look to see what the challenge is. If it's an irrationality challenge, in relation to what is the irrationality being claimed? And I'm talking about a legality challenge of that kind. If it's a question of an infringement of a Bill of Rights and an unjustifiable impingement of fundamental rights, then you look at to see what the right is, which regulation it is said impinges on that right. And then you look to see whether, if there is an impingement, that impingement is justifiable. I mean, and again, talking about people who taught us, answer the questions that are in front of you. Don't answer the questions that you've thought up and think are quite clever. The real question is, what are the pleadings say here? Whether or not they justify, whether the conclusions are justified on the pleadings, what are the pleadings and what are the facts on which the judgment was premised? And we've gone through that ad nauseum. Mr. Trengove assumes the position that the pleadings are dispersed, that they aren't, you can't actually quite easily categorize them. That's what he put out. Your submissions, I don't think, are different.
That is so, Justice Nipson. The real problem is, I respectfully submit that the concept of irrationality as a ground of review has been given a very specific meaning by our courts, and consistently so, as not related to the purpose for which the power is given. And it is used. We use it in our common language in a broader way as something which doesn't make sense. And something that doesn't make sense doesn't necessarily give rise to an irrationality challenge as a ground of review. It may be arbitrary, may be unreasonable, it may be disproportionate, but it's not irrational in the legality challenge sense. That is really the only point I would make about that.
Do you have anything further to add?
Very briefly, just to say something about judicial overreach. I draw attention to the following as to what the court did. Firstly, it declared regulations invalid, despite apparently finding that they were not invalid. Because if you read paragraph 1 of the court's order, all of the regulations are declared invalid, yet paragraph 7.14 of the judgment says some of them apparently seem not to be invalid. So the premise, the founding paragraph is inconsistent with the judgment and inconsistent with what the judge apparently intended. Secondly, the court declared regulations invalid without giving any reasons why they were invalid. It said, well, we can assume that they're all invalid because I've seen that some of them are invalid. That's paragraph 7.13 of the judgment. It's deeply ironic in a case where the learned judge criticized the minister for not giving reasons for what she'd done. He'd made orders of invalidity without saying why there was an invalidity. Thirdly, the court ordered the minister to make new regulations within a specified time. This canvass with my learned friend, Mr. Trengove, the point that the Lord Justice Nafsa made was, we know how these things are usually, how orders of this kind are usually made. Usually there's a declaration of invalidity and an opportunity to fix it. So suspension for a period. But here there's an order on the minister to make the regulations. And if the minister doesn't do what the judge actually intended, she may be in contempt of court. And what precisely she was obliged to do is not clear. Justice Ponnen may remember the Kloof Conservancy case, which was about a similar sort of thing where the minister was ordered to take reasonable steps to do something under threat of contempt proceedings. And this court said, you can't do that because how's the minister supposed to know what she's got to do to avoid being in contempt? And so the problem arises from the court doing the wrong thing. Instead of saying, I declare invalid and I give you an opportunity to fix it, it was, I declare it invalid and I order you to fix it. And I order you to do something, and something which is indeterminate. Then the final, and then finally, I've made the point made already, the court declaring invalid orders, regulations which weren't before it. And so this is, in truth, a case of judicial overreach. And it was made, no doubt, with the best of intentions, but with the greatest respect, it would be appropriate for this court to say something about that. That this endeavor, an endeavor of this kind, in the end, undermines the endeavor of the courts to hold power to account, because the courts look as though they're meddling in and doing things which really they don't know about, and things which are not before them, and things which they've plainly got wrong. And so the need for care, not caution, the need for care is right at the forefront. And I do make the submission that a judgment of this kind undermines the attempt the courts make to play the role which is constitutionally assigned to them, because they undermine public confidence in the courts and in their ability of the courts to carry out the delicate balancing exercise which they are required to do by the separation of powers. There's a lengthy passages in the courts in the judgment referring to the separation of powers. The court refers to the principle, but one looks in vain for any attempt to apply that principle to the facts of the case and to the case as pleaded. So those are our submissions, Justices, unless there's further questions.
Thank you. Let me just see. Any of my colleagues, further questions? Well, we're now at the point where we'll reserve judgment. We will deliver it in due course. You're all excused after the adjournment. My colleagues and I will confer with each other separately. Thank you. Judgment is reserved. Court will adjourn.
As the court pleases.
Judge? Judge? We can join on another link, right? Yes, thank you. You are muted.
It's like, how did I do it? Yes, there's no criticism about that.